because the subject is very, very important and very interesting. And all the more we have such a person, I am completely impressed by the style in which he presents himself and makes the subject so very interesting. It's not just because he is here, and we have seen him as presented in a moot court, and now as a resource person, and he has delivered wonderful lecture on assisted reproductive technology. You all know that in 2022 important legislations were made, were passed rather by the Parliament on assisted reproductive technology, and I think we were the first law college, if I could say so, in the whole of India, because I tried to search and I couldn't find any workshop or seminar conducted on that topic. And we could do it only because we had many doctors with us. One of the doctors being Dr. Suyash Patankar. Yash, he is so very popular. He is a well-known plastic surgeon, and Su, the prefix to his Yash, stands for all wellness and goodness. And as he very beautifully said, what matters now is all the love and the best wishes he has from all his patients and other well-wishers. So you can see his qualifications. He has been brilliant as a student of medicine, and I have seen him as a student of law in the same college, in the various classrooms, and particularly I have still preserved his moot court memorial. It's there on my table even now. He had taken it in a very different manner. The appreciation of facts given to him was done superbly. Even I had not planned it that way, and I was really surprised to see that particular set of facts could be seen from this angle as well. So he is such a brilliant person, and he has constantly, even now, he is trying to upgrade himself, and he is a certified mediator. I told you, mediation is becoming very, very important because we are sick of delays and in the litigation and the docket congestion. We are trying to find every method by which we can bring promptness in the justice delivery system. There is no justice if there is no prompt delivery of justice. What is the point getting justice after a decade or so? So for that we believe that mediation can be very, very important. In August 2020, Bar Council of India made a circular calling upon all the universities to have a full-fledged course on mediation and conciliation. But it has not yet been acted upon, including our university, and I am not very sure what are the steps taken by other universities. We are in the process. So I am telling you this only for the purpose, only for this reason, that the subject is becoming very, very, very important, because we believe that mediation is going to help us come out of this docket congestion, and it can be very meaningful, because there won't be hostile litigation, but the parties can be brought together and they can be participants in the resolution of their own disputes, if I'm right. Of course, we are going to have a full-fledged workshop on this topic. So that is the reason why we think the workshop, this mediation is going to help us very much. And first year students, you may remember I promised you that you will have a workshop on mediation, and I just skipped chapter 5 of Consumer Protection Act 2019. There is a chapter on mediation, and consumer dispute comes before the court, before the commissions, district or state or national commission, the first endeavor of the commission would be to ask them whether they would like to go for mediation. And if the parties agree, the matter will go for mediation. So to this extent, there is faith reposed in mediation as a very potent dispute resolution mechanism, and it's high time that we become familiar. And there is a mediation certification program also. Certified mediators alone are engaged in this. So sir has qualified in that as well. So we have Dr. Suyash Patankar to talk to us and make it very familiar to us about mediation, the law and the procedure. So with these words, I welcome Dr. Suyash Patankar. I welcome my colleagues and all my students. We will all be ears, and we will be looking forward for the interesting session that you are going to do. Welcome, sir. Thank you.
Thank you so much for your kind words. They really mean a lot, especially coming from you, the person I deeply respect. Thank you so much. They really mean. Hello everybody, am I audible? Yes. Or do I need to use the mic? No, I think I'm good. All right. So it's so good to be here. A few years back maybe, I used to be sitting there, like one of you faces. And when I came down, the thing that I realized was, yaar, आमच्या वेळेला तर एवढा brightness नव्हता. And then I realized it's all those pretty faces in the traditional, on the traditional day. Why there is so much of dazzling beauty and light today. Anyways. Okay, so it's so good to be here. It's really an honor to be amongst yourself. All right. So, mediation in India. We are going to talk about, the topic is basically legal provisions, science and art. However, we're going to mainly cover the legal provisions and the science part of it, but we would probably leave art a bit aside. The reason is very simple. Somebody can talk about how can one make a beautiful painting in 1 hour, but for you to be actually able to do that or learn to make a painting, definitely going to take much more, not an hour, right? For the recording purpose. Oh, okay. So my one hand. Okay. So my one hand gets occupied. All right. So as I was saying, so we leave the art part of it aside. It takes a long time to master the art part of it. However, we will at least get introduced to what mediation is and how do we go about it. So mediation in India. It's the movement of mediation is just about starting in India. It's just in roots. It's just showing some green shoots. So maybe you guys are at the right place at the right time. You may be the torch bearers of this movement going forward. So you are really, really lucky to be the torch bearers or the beginners of this movement of mediation. So when we say this mediation is just about starting in India, does it mean that mediation is a new concept? Well, ma'am already said there was a concept of madhyastha, right? तुमच्यापैकी मराठी किती बोलतात? बहुतेक जण सगळे व्हेरी गुड. सो तुम्हाला माहिती आहे कौरव आणि पांडवांच्या युद्धाच्या आधी श्रीकृष्णाने काय केलं होतं? दोघांमध्ये मध्यस्थी करायचा प्रयत्न केला होता. व्हॉट इज मध्यस्थी? मीडिएशन, राईट? द फॅक्ट रिमेन्स दॅट द मीडिएशन फेल maybe for the better or a larger design the God had in mind. So the mediation failed, but the mediation concept is not new. जेव्हा आपण म्हणतो की देवाने केलेलं मीडिएशन सुद्धा फेल केलं, तर डज इट मीन मीडिएशन इज व्हेरी डिफिकल्ट, राईट? ओके. आपण किती वेळा बघतो की दोन बहीण भावंड भांडत असतात. एक चॉकलेट असतं त्याच्यावर भांडत असतं. दोघांनी चॉकलेट हवं असतं. आई काय करते अशा वेळेला? एका धपाटा घालत नाही, बरोबर? What does she do? She tries to resolve the dispute in a manner that the bond of love between the two siblings will not be broken. Right? That's the essence of mediation, my friends. Mediation retains the bond between the quarreling or warring parties and does not allow it to be broken. And that is the basic difference between litigation and mediation. So let's talk about disputes, alternate dispute resolutions, mediation, conciliation, and all those things in quick succession. So, kadi dispute hoto, how do we respond to the dispute? So what are our responses? Typically, these are the ways in which most of us respond to disputes. Some will try to avoid the dispute altogether. Okay. Some will try to accommodate the other person. Whatever the other person wants, we try to accommodate that person. Some may actively negotiate with the other person and try to come out of it. Some may actually collaborate. Or they may appoint a third person who will direct them कि तुम्ही काय करा. That is arbitration and litigation. Right? तुम्ही काय करा. So what is area? तुम्हाला alternate dispute resolution आहे, बरोबर? So what is area? Any method of resolving dispute other than litigation. So बाकी सगळे area. एक litigation सोडलं. So this is a gamut of all the things which are possible to resolve a dispute. The bottom line is litigation. त्याच्या वरती जे सगळं आहे, everything is area. Alright? And त्याच्यापैकी from avoidance to mediation and conciliation, the decision of the parties. The parties make the decision. Nobody else is dictating decision to them. So they have a complete freedom to take a decision. While the rest of the things, third person is assisting them or telling them what to do. And of which the bottom three, arbitration, tribunals and litigation, the decision of the third party is binding on the parties. They cannot get out of that decision. As we move from avoidance towards judicial decisions, the possibility of win-lose outcome increases. आपण कोर्टामध्ये केस मराठीत बोलताना काय म्हणतो, एक जिंकला एक हरला. Somebody won the case, somebody lost the case. So there's a win-lose there, right? And so also, as we go up the ladder towards litigation, the cost and the hostility, those are increasing. So if you want to avoid that, then probably what are the alternatives to it, or what is a good option to it? There are basically, broadly speaking, two options: adversarial, which is litigation arbitration, and non-adversarial or resolutionary, that is mediation and conciliation. Okay. So, आपण क्विकली बघूया की लिटिगेशन मध्ये आणि mediation मध्ये essentially काय फरक असतो. Alright? In order for you to understand that, we'll carry out a very simple exercise. Can I just have two volunteers here? Maybe, yeah, okay. I'll give you some facts. Okay. Now there is a dispute here, and let's see how it plays out in litigation, how it will play out in mediation. Okay. The facts are very simple. Can you show this for a moment? I was feeling hungry, so I bought this. Okay. All right. So that's an orange. Now she has a beautiful house with a garden around it. त्याच्यामध्ये orange झाड आहे. She wanted orange for some purpose. झाडावरती she climbed the tree to pluck the orange. The orange काढताना हातातनं सटकलं आणि खाली पडलं. It fell beyond the compound wall and fell on the road or the pavement. तसंच लाईटला पडलं. She got down from the tree. Gate मधनं बाहेर जाऊन ते orange घेईपर्यंत he was walking on the road. He found this orange. त्याने आजूबाजूला बघितलं कोणी नाहीये. He just picked up the orange. She asked him to return the orange. He said no. मी काय देणार नाही. मला मिळाले आहे माझं. Okay. So now she has gone to the court of law and trying to claim her orange back. So that's what litigation does, right? She wants to claim ownership. So can I request madam to please be the honorary judge here? Okay. So she's the honorary court here. Okay. And that, my dear friends, is Exhibit A. Exhibit A sits right there. All right. So let's hear the arguments from the plaintiff first as to why she, or on what grounds does she want to claim the ownership of the exhibit or the orange or the subject matter. Your name please? Okay, Priyanka.
My lord, as I stated in a Thane, I am the owner of the house and there is a small garden outside the bungalow. So, as stated in the facts, I would like to bring to the notice of the court that under section 71 of the Indian Contract Act 1872, that is a finder of goods, the person who finds goods belonging to another, he is under a duty to take care of that and is under a responsibility to return it when he found the true owner. So I would like to mention here, if I am the true owner of this house, so I am asking for the my goods, that is the fruits that belongs to me, because that house and the garden belongs to me.
Okay, let's hear the difference.
Your Lordship, I am not denying the allegations made by the plaintiff, because as per section 71, which was quoted in the plaint, it is very rightful. She has mentioned that as the holder of the goods, I have to return it back to the real owner. But my submission here is what is the true evidence and what is the proof that the plaintiff is the real owner of the orange, because in the plaint there is no such submission where she can prove, and she has a hardcore evidence where she can very promisingly convince to the court that she is the real owner of the orange. Me as a defendant, I am not denying that I am the sole owner of the orange, or I have the sole right of enjoying the fruits or the benefits of the fruit. I am not denying that. I am just placing before the court that she doesn't have that the plaintiff doesn't have any evidence where she can prove the orange is hers.
Excellent. So now based on these arguments, let's hear the verdict.
The parties are being heard. The plaintiff and the defendant have presented their respective cases. The plaintiff is the owner of the house and has a garden, has been continuously watering the plants there, and the orange tree has borne a fruit. The fruit has accidentally got into the hands of the defendant, and it is completely very surprising to this court that the defendant makes a claim to the orange that he has picked up. In our jurisprudence, the property right is a very cherished right, and property rights are based on the labor, and the plaintiff is duly entitled to the fruit borne by the tree which she has watered, she has nourished and taken care of. So the court awards the ownership of the orange to the plaintiff.
Okay, and the boy who gave that exhibit to it. Okay, so plaintiff gets this, right? Okay, so obviously now she is a winner, he is a loser, right? So their relations, if they were friends before the case came up for hearing, is broken forever. Right? One person is a winner, the other person is a loser, and it's permanently broken. Now let's see how the same scenario will play out under mediation. So shall we? Okay. Now as you realize here, the honorary court or the judge was sitting on a pedestal high up and not approachable by anyone. Mediation process is completely different. We are going to be very, very informal, and we can either sit here. Would you be able to see? Otherwise, all three of us can sit there, so that everybody sees us better. Would that be better? Should we sit there? Okay, come, both of them. Okay, for mediation, we never sit like this. It's for your understanding and convenience that we are sitting here. Otherwise, we'll be sitting around a table with a nice cup of coffee in the hand. Everybody sipping a cup of coffee or tea or cold drink or whatever, and very, very informally chatting. Okay? That's it. When we begin the session, it's like we are facing each other, it's not like we are facing there. And I will introduce myself as to, I'm Dr. Patankar, I'm a mediator. Thank you for choosing me or having me as a mediator. I will try to establish my credentials as a mediator and emphasize my impartiality. That I don't know either of you, nor am I interested in having this orange. I'm not interested in subject matter either. So I will emphasize those facts first. I will make sure that they are the ones who have the authority to come to a settlement. If somebody is representing a company, so whether that person has an authority to enter into an agreement or not, I need to emphasize that, otherwise the whole exercise is a waste. Right? So I will emphasize that and then gradually lay down the rules or explain to them how the process will take place and carry it forward. So these are some basic tips that I am giving you how the mediation takes place. There are so many things, but we're just running through it. Alright. So when we go through the process of mediation, I will ask them to narrate the facts one by one, and I would listen to those facts. When I listen to those facts, what is very important is active listening. I don't know how many of you are, aware of this concept. Active listening. It's not passive listening. म्हणजे तो काहीतरी बोलतोय, माझ्या डोक्यात काहीतरी एखादा मूवीला संध्याकाळी कुठे जायचा त्याचा विचार चालला आहे. That is not listening. Active listening. I should be actually engaged in it, absorbing every word that he's saying. Not only every word, but even a facial movement of his facial muscles, his body language, his states. There are subtle clues a person gives away when the person is telling a lie. He'll make some nervous gestures, he will try to avoid looking into your eye, all such things. So they are called soft skills. So as a mediator, I really need to develop those specialities in order to gauge what a person is really trying to say. So many times they will put forth a different spin to what they really want, but we need to really basic or go below the surface to understand what they really want. Okay, so for paucity of time, I'm not asking them to narrate the facts once again because we're all very familiar with the facts. Otherwise, they will turn back and narrate the facts. Maybe if I have doubts, I will ask them about clarifications, repeat the facts so that they ensure that I have understood them correctly. Thereafter, then it's up to me either to conduct a joint session or a separate session or a private session. Now, in litigation, then nothing like I'm sorry, I'm sitting here because in mediation we're supposed to sit. That's why I'm sitting and talking and explaining to you at the same time. Okay? Yeah. So in litigation, then nothing like a separate session. Everything happens in front of both the parties. Right? There's nothing like a session going on where the other party is absent or not allowed to be there. In mediation, I have a freedom to do that. So sometimes we do that. So for you to understand better, we'll assume that I'm entering into a private session. So I will ask them, is it okay that I talk to you in absence of the other person, turn by turn, so that you can speak your mind out without being worried as to what you are conveying will reach the other person. So they can frankly speak to me about whatever their points are or concerns are without conveying to the other person. So if they are okay, then we start it, then I ask them who wants to go first. So I assume that given me the permission and I am going first. Alright? Okay. So then we start a private session. Suppose, imagine he is not there in the room now. We just, me talking to her. Okay. So I understood what all the things you told me. If I am not mistaken, that you have a beautiful house, beautiful garden around it, and you have some trees. So you have plenty of trees there. How many trees do you have, or what are yours? All fruit trees, or garden, or what is it then?
There is one big tree of orange tree.
So you have one big orange tree. Okay. And as I understand, you were trying to pluck the orange tree, and you say that it slipped out of your hand, it fell down, right? Can you tell me, when did this happen? What time of the day was it that you were trying to get it down? Morning, afternoon, late evening? When was it?
It was during the afternoon. The reason behind it, shall I?
So you were trying to get it down in the afternoon, but afternoons are so hot and sunny. So why did you really need to climb the tree in the afternoon to get it down? Was there some sort of an emergency that you needed it, or why did you really get it down?
Yes, sir. My son is ill with a high fever, and doctor suggests me to make a kada for him out of the orange pills.
really, your son is not being graded, so you need the orange peels to make a concoction out of it so that you can treat his fever, right? Okay, so it's something really urgent for you that you need it immediately kind of a thing. Okay. Now I'm going to discuss with her 3 things, what we call Patna, Vatna and Malatna. What is this? Best case scenario, worst case scenario, or most likely scenario. Best alternative to negotiated agreement, worst alternative to negotiated agreement, most likely alternative to negotiated agreement. This is for your explanation. Okay? Alright. So it's something urgent for you. Now tell me something. Suppose she has not heard the court verdict because she has come for mediation. So the ruling of the judge has not gone in her favor. Okay? So what do you think would be the best case scenario? Naturally, the court will, if mediation fails and you proceed with the civil suit that you are filing, the best case scenario will naturally be that you get the ownership right on the orange, right? What do you think would be the worst case scenario? Yeah, through the litigation, what would be the worst case scenario for you? Okay, I will help you. The best case scenario would be you lose the case and you don't get the ownership of the orange, right? What do you feel is the most likely outcome that can happen?
I might get the ownership of that orange, and with this, even though he's my neighbor, I might lose the orange.
So you will get ownership of the, that's the most likely. So you are very optimistic that you will win the case. Knowing the way our judiciary works, how long will it take, you feel, for the verdict to come in your favor? It will come in days, months, years. It will take a long time, right? Okay. So if you get the verdict in your favor a few months from now, is it going to help you? Because you will need the orange now to treat fever of somebody in the family. Am I right? Okay. So in that case, it's not going to be really helpful to you even if you win the verdict in your favor. Am I right? Okay. So then will you be open to having, as it is your need is for the peels, for the rings of orange, right? So will you be open to a possibility whereby you just take the rings or the peels of the orange, but give the orange away, which you don't really need. You have a tree, you can have as many oranges as you want going forward. Will you be open to that possibility? So now she has agreed to that possibility. Okay, now I have that at the back of my mind. Then I call him in the room. I have a private session with him. Again, we go through the same motion. I am not explaining how we go through it again. Okay, and then I ask him, why does he need the orange?
Sir, I need the orange because personally I have a fond liking for that fruit, and the fact that it was just lying on the
whatever juice or you want to eat it. So he's interested in the fruit part of it. So as it is, you were going to purchase the oranges, or you might pick up the orange, you are going to eat the orange. What are you going to do with those peels?
peels just after going to throw away.
Is it okay? Is it okay then if you get that fruit and you just gave away the peels to somebody who needs it maybe? Is that okay with you? Yeah. So then we have a win-win situation here, where I call both of them in. She agrees to take the peels and give away the orange to him, and both go back happy. Right? This is what the mediation does for everybody. Alright? So, shake hands on that, and your friendship is intact. So this was a makeshift thing, but this is what it does. And now probably we can see what all things played out in this session. Okay. So what all things played out here, and what is basically a difference between the procedures that we just saw? Okay, the role of neutral is completely different, right? As a mediator, I was sitting with them, and it was quite, the process was completely different. It was very, very informal process. I was approachable to both the parties. There was no real stress there. There was no, it was not bound by CPC or Evidence Act and all those things. The parties themselves could talk to me freely. They did not need to appoint an advocate to plead their case, nothing of the sort. So it was very easy, much less expensive for them. And what are the subtle differences? Should I wait there? Okay. All right. Okay. And what are the subtle differences if you noticed in it? In litigation and arbitration, it's all about what happened in the past and whose rights are better. ऑरेंज पडलं तेव्हा काय झालं, मग तेव्हा तो आला तेव्हा आजूबाजूला कोणी होतं का, त्यांनी रिअल ओनर शोधायचा प्रयत्न केला का. सो इट्स ऑल अबाउट पास्ट अँड हुज ओनरशिप राईट इज बेटर. While in mediation, you are looking at future. पुढे जाऊन काय करायचं, याच्या पुढे काय करायचं आपल्याला, and how the interests of all the parties involved can be best served. You are not really interested in rights, you are interested in interests. Whose interests can be better served? How can we serve the interest best? So that is a basic, essential difference between the two processes. Now, for the sake of completion, let's go through some grab part of it. The legal provisions. So we saw the difference between litigation arbitration and mediation conciliation. Now let's see the difference between conciliation and mediation. Alright? So conciliation is a conciliator, mediation is a mediator. Okay. Conciliation is more evaluative. It focuses on issues, while mediation is more facilitative. It focuses on interests, like we just saw. Conciliator gives suggestion, or is open to giving suggestions, so he can steer the course in a particular direction that he wishes to take it to. Well, mediator will never do that. As a mediator, I will strictly ask only open-ended questions, not the leading questions. So I will never try to steer it towards his direction or her direction. Okay, I will strictly try to stay in center and let the parties decide wherever they want to take it. Now some legal provisions, you are all aware of them, I guess, so we'll just run through them again. Conciliation is governed by the Arbitration and Conciliation Act 1996, Part 3. This is the basic, essential difference between the two. While mediation, there is no statute governing the process of mediation. There is no single comprehensive statute governing it. The mediation bill is still pending until it comes in force. There is no single statute governing the process of mediation. The process, the situation slightly changed after the Consumer Protection Act came, new CPA 2019 came into force. But again, CPA 2019 deals only with consumers and consumer complaints. You studied Consumer Act, right? Yeah, so it defines consumer, what is consumer complaint and all those things. So it deals only with consumers and consumer complaints, but does not deal with other disputes. Conciliation Act says, Section 73, parties may draw up and sign written agreement. So it's optional. It's not mandatory for the parties to draw up the written agreement. The same holds true for mediation. But the difference is, if the parties, in conciliation, if the parties do draw up an agreement, write it down and sign, then it becomes binding and enforceable. Okay? Section 74 says that settlement agreement is at the same pedestal like an arbitral award, and Section 36 says arbitral award can be enforced like as if it was a decree by a court as per CPA provisions. So in short, the settlement agreement of a conciliation can be enforced through court of law, while mediation agreements are not legally enforceable as such. If the agreement is written down and signed by the parties, at best it can act as a contract between the two parties. One party can probably, if there is a breach of contract, the party has civil remedies available against it, but otherwise it is not legally enforceable as such. Let's run through some provisions of new CPA now. CPA 2019, Chapter 5 deals with mediation. Section 74 says that government, central and state governments will appoint mediation cells. 75 says tenure will be for 5 years. 77 says mediator to disclose personal, professional and financial interest. In short, we should be unbiased. 79, section 79, mediator to have regard to rights and obligations of parties, usage of trade, circumstances giving rise to dispute and guided by principles of natural justice. So it does not have to be bound by CP or Evidence Act. The process is pretty informal, guided by natural justice. Section 80 says if agreement is successful, then what do you do? How do you go about it? Terms to be reduced in writing, signed by parties or authorized representatives. Again, parties themselves don't have to be part of the conciliation proceedings. They can either choose to be part of proceedings by themselves or through any appointed authorized appointees or through their councils. So they have a freedom either way. Mediator to prepare the settlement report and forward the report to the Consumer Commission. If the agreement is not reached, the conciliator will send the report accordingly. Okay, section 81 says that if the dispute is settled, the Commission would pass a suitable order within 7 days of receiving the report. And if the dispute is settled in part, then court will continue to hear the issues which are not settled and take those issues which are settled on record. Now, these are some regulations formed under the Act. Okay. Now, eligibility for empanelment as mediator, those who are interested to become mediators and get empaneled in future, probably they will have to know this. Who can get empaneled as a mediator to the Consumer Commissions? Retired judges, retired members of Consumer Commissions, mediators empaneled to honorary Supreme Court, High Court or District Court mediation cells. Experience in mediation and conciliation for 5 years, retired judicial officers with experience more than 10 years, advocate with the experience of more than 10 years at bar, and experts or other professionals with experience of more than 15 years. Let us run through them very quickly. What are disqualifications? First four are common to most of the statutes which you have read, so I am not even going to read them. Okay. The last is the mediator should be unbiased, should not have any personal interests involved. Code of conduct, again, will maintain its impartiality, disclose if there is any professional involvement or personal involvement of his, and shall not communicate with the parties behind somebody else's back. These are the rules as to, regulations as to how the proceedings will be conducted. The parties can appear, as I said, personally or through representatives. The time frame is usually 3 months from the date of first appearance. Consumer Commission can always extend the date, guided by principles of natural justice, not bound by the CPC or Evidence Act, and if a party does not participate or does not attend the proceedings, then Consumer Commission can direct the party to attend them. It is expected that parties shall provide all the relevant information. The record of the proceedings shall be prepared by the mediator on every date and shall be signed by the parties, counsel or authorized representatives or attorneys. Now this is slightly different from what we do in private mediations. Okay. Now this makes it binding that at the end of every mediation session, we will write down everything that has transpired there and it will be signed by everybody. Now in private mediation sessions, it's open to us and the parties as to whether they want any records to be maintained or not. It's possible that some parties will hesitate to have anything in one paper. So they will say, no, chitti vardi sudha as a chitti ko program. They don't want to, that something can be produced in the court of law later. Whether it can be, we see that, but they have the fear in mind. So in that case, we do not write anything, or if we write anything, to destroy it in front of the parties at the end of the session, day by day. So it's slightly different from private mediations. The agreement executed between the parties shall be submitted by the mediator to the Consumer Commission in a sealed envelope with the forwarding date. Okay. If no agreement is executed between the parties, this is very important. Mediator shall intimate the Consumer Commission without disclosing what transpired during the mediation proceedings, what are the stand taken by the parties, and why the agreement could not be reached. Because the Commission is expected to hear the issues and conduct the proceedings. So, Consumer Commission should not get biased by all this information coming their way. And if this information was to be diverged to Consumer Commission, and if the Consumer Commission was to get biased, mediation proceedings मध्ये कोणी मनमोकळं बोलणारच नाही. Right? प्रत्येकाला वाटतं मी काय बोललो ते कोर्टाला कळलं तर माझ्या विरुद्ध रिझल्ट होईल. So to avoid that, these are some safeguards there. Mediator shall not communicate to Consumer Commission except by his report and after giving copies to all the parties. This is to ensure that nothing is shared with the court behind somebody's back. Now, what is the role of mediator? To facilitate a voluntary resolution. So mediation conciliation is a completely voluntary process. assist in removing misunderstandings. That is what mediation does. A number of times, the whole crux behind the whole issue is some small, simple misunderstanding. And until that misunderstanding is rectified, nothing is going to fall in place. So all the tall monetary claims and everything can just arise from a simple misunderstanding which can be ironed out through one-on-one talk or understanding what the real issues behind the or under the surface are. Generate options to resolve their disputes. In mediation, we can tailor-made the options, bespoke options, what we call. Okay, so tailor-made the options in order to suit what is required. For example, now court of law may not be able to do this. कि 15 साल तो get 15 हो गए. In mediation, we can do that. These are tailor-made options in order to resolve the dispute. And shall not impose any term or any settlement upon the party. I am not the one who is going to dictate to the parties that we have to act or not. It is for the parties to decide what they want to do and what is in their best interest. Confidentiality strictly has to be maintained, so there are some provisions regarding even the regulations. The mediation rules which are framed state that if the Consumer Commission refers the matter for mediation and mediation is successful, the fees are refunded. There is a bar of simultaneous arbitration and litigation, otherwise it will defeat the purpose. Death of a party after settlement agreement does not change anything, but it still stands. Now these are important. Matters not to be referred to mediation. What are the matters which cannot be referred to mediation under the rules? Offences for which applications for compounding of offence have already been made by one or more parties. Prosecution of criminal and non-compoundable offences. Medical negligence resulting in grievous injury or death. Serious and specific allegations of fraud, fabrication of documents, forgery, impersonation and coercion. Cases which involve public interest or the interest of numerous persons who are not parties before the Commission, and it appears to the Commission that the settlement is not possible. So these are the cases which cannot be referred for mediation. I am not going into details as to probably what's the thought process behind these things. Maybe some simple procedures where compounding is easily possible, or some serious cases where it should not be settled. In short, in India, we don't allow blood money. You murder, pay, and get out. We don't allow that. No? This is basic principle behind it. Okay, now disputes which are suitable for mediation. Anywhere where the parties are interested in maintaining their cordial relations with each other, mediation is the way to go. So all the disputes where that is very important. And it serves purpose in commercial disputes. Say for example, just to give an example, I have a car dealership and there is a customer who is not happy with this and so there is a problem. Now I am interested in maintaining the relation with my customer, looking at the future business, maybe he wants to change the car next time, he will come back to me. The customer is interested in maintaining the relations with me because he has to get a car to me for postal service for maybe 2, 3, 4 years going forward. So we need to maintain relations with each other. So partner mediation is a better option than litigation. Partnership forms. Usually partnerships are between friends, relatives, or whatever people we know. We don't form partnerships with an unknown person usually. So we want to maintain those relations. Family members, workplaces, employer-employee relations, industrial relations, etc. Okay? So these are the mediations which are suitable for this. What are the basic benefits for mediation? It's quick, less expensive, less stressful. Litigation can take months and years together. But here, those issues can be resolved within a matter of an hour or 2 or 3 maybe at times. Just 1 or 2 meetings and the matter can be resolved. It's less expensive, much less stressful, very, very informal. You don't need advocates, nothing. You can just have a chat and resolve it. Informal, flexible. And most important, the parties have a complete control over the outcome. They are not bound by, I have to come to a settlement or I have to buy, it is binding on me. No, it's completely open to them. And they have also exit option. See, 9 more mediations are not there. I don't want to continue with it. I just end it. Period. That's another story. You can continue the litigation thereafter if you want, for years to come. Safe space for affording writs, confessions, and apologies. My friends, this probably is the biggest benefit of mediations, what I have realized over the years, which litigation does not allow. Okay, I'm telling you a story where there were 2 friends had an opportunity to mediate between them. There were 2 friends, there was some discord, there was some misunderstanding, and then त्याच्यावर त्याची काहीतरी monetary quarrels झाल्या, it went into litigation, then they came up for private mediation team. because you heard from somebody that probably that would be a better approach. And I realized there was a very, very simple misunderstanding between the two friends. You know, that in close friendship, one friend felt that he was being taken granted by the other friend did not even realize that was happening. And what it needed was, अरे मी जाणून नाही केलं, मला कळलंच नाही की तुला असं वाटतंय. आणि तुला असं वाटलं असेल तर I'm sorry. I never meant it. That was all that was needed. And trust me, first meeting itself, everything fell apart, and they were just, you know, like an hunky-dory when built like a snakes. So that's what mediation does. And obviously there is a win-win situation for everyone. Right? It allows rapport building, often improves understanding between the parties in an ongoing relationship, where we are interested in maintaining the ongoing relationship. Creative solutions, we talk about that, bespoke outcomes, or tailor-made outcomes, we spoke about that as well. It offers an opportunity for finality closure. वर्षानुवर्ष आपण बघतो लिटिगेशनमध्ये अक्षरशः वर्षानुवर्ष जातात, लोकांचं आयुष्य जातं, ती केस चालू असते. केस चालू असेपर्यंत 10 वर्षामध्ये some parties die, त्यांची मुलं ती केस पुढे चालवत राहतात. They are spending huge amount of money on the advocates, and for what? It's a better idea at times to have a closure to it sometimes, so that they can continue to lead a fruitful life thereafter. There's life after that as well. That's not the end of life. Winning or losing the case is not the end of it all. Right? So, opportunity for finality and closure. Compliance with agreements is usually high. I mean, as a mediation, मध्ये म्हणतो की written agreement ची mediation मध्ये गरजच नाही. If there is true meeting of hearts, then we don't need a written agreement. Okay? So the agreements don't require enforcement. Having said that, जगात सगळ्या प्रकारची माणसं असतात, तसे सगळे अनुभव आपल्याला असतात. So mediation मध्ये सुद्धा agreement झालं तरी सुद्धा कधी-कधी enforcementची गरज पडते. Sometimes it happens की agreement जे आहे that will continue for a long period. मग जर का 2-4 वर्ष त्याचे agreementचे जर का compliances चालणार असतील तर तोपर्यंत interest of the parties change. Sometimes the parties themselves change. There is something called as a buyer's remorse. आपण काहीतरी घेऊन येतो, मग घरी आल्यावरती वाटतं अरे यार उगाच घेतला, आपल्याला आणखी स्वस्त मिळालं दुसऱ्या दुकानामध्ये. You know, working for a buyer's remorse. So then, no, I should not have accepted this. Maybe I would have got a better deal. So that kind of a remorse. So many things can happen. And we need at times something to enforce it. So what do we do then? Until the mediation act is passed, what we do then is mediation agreement is clothed as a conciliation agreement. And mediation agreement झाल्यानंतर we ask one of the parties to send a written invitation for conciliation. The other party accepts in writing, mediator acts as a conciliator, and the whole agreement is a conciliation agreement, and it becomes binding. Simple, we don't have terms. Okay? Again, yet there will be some difficult positions. काही difficult लोक असतात, they are deeply entrenched on their positions. मी हे म्हणतो म्हणजे असंच व्हायला पाहिजे, नाहीतर नाहीच. But adamant about those things, right? That's when the difficulty arises. Then what do we do? And that's where the art part of the mediation comes in. How do we circumvent these problems? How can we break below the surface or entrenched positions of these people? How can we really judge what their true interests are or intentions are, and how can we really serve their interests? So that's where the art part comes in, and there's a whole different talk on it probably, so not today maybe. In a nutshell, the art of mediation, if I could tell you in one sentence, it is dividing a cake in a way that every person leaving the table leaves happy, believing that he got the biggest piece. Very simple. That is mediation in one sentence. Okay? So having heard this now, probably it's for you to decide as to going forward whether you would want to practice as litigating advocates and go towards judicial litigations, or you would prefer to become a mediator and really help those people get over their issues very quickly and in a very easy and applicable manner. Now for those who are worried about the financial aspects of all this, I would end by a quote from Abraham Lincoln. And he said, discourage litigation, persuade your neighbors to compromise wherever you can. Point out how the nominal winner is often the real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. And that, my friends, is mediation for you. It's up to us to decide whether earning money alone should be the motto of our life, but at the same time, if we wish to become a good man and help others solve their problems. Thank you so much.